Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We had a quick update late last night in the Justin Baldoni versus Blake Lively case. The parties have been arguing over a subpoena from Blake Lively to Bryan Freedman's law firm. Now, Bryan Freedman is the head attorney for Justin Baldoni and the Wayfarer parties. She claims that Bryan Freedman is a co-conspirator in this smear campaign, she alleges, and believes that he has defamed her through his interviews where he defends his client. They had a hearing in that a couple days ago. The judge hasn't ruled on it, obviously, but Blake Lively's attorneys had filed yesterday a letter to clarify some things that they had said. Apparently, one of the instances in which they refer to Bryan Freedman allegedly defaming Blake Lively was during one of his interviews with Megyn Kelly. It was the one after the judge had dismissed most of the Wayfarer party's counterclaims against Blake Lively. But in that interview, Megyn Kelly was sharing her unfavorable opinions, using some strong words and harsh language, but she's allowed to do that. Anyways, the Wayfarer parties have now written a letter to the judge regarding this same subpoena to Bryan Freedman's law firm. They're explaining why they believe it needs to be quashed, and they even have a quote from Lively's deposition in here. Now, Exhibit A is the transcript of Blake Lively's deposition, which is sealed. The public cannot see it. So the quote as well in here is redacted, but they kind of describe a little bit of what's going on. Dear Judge Lyman, we write in response to Blake Lively's letter concerning Liner Freedman's motion to quash the subpoena that she served upon the law firm. And Liner Freedman is, of course, Bryan Freedman's law firm. To justify the harassing subpoena, and where else have I heard that she's been sending out some harassing subpoenas? To justify the harassing subpoena, the letter erroneously alleges that Bryan Freedman defamed Lively and that his conduct had amounted to public relations work rather than that of an attorney. It appears that Lively is slowly realizing there is no retaliatory smear campaign by the Wayfarer parties against her. Too slowly, if you ask me. Consequently, Lively is shifting her focus to Liner Freedman in connection with her 14th cause of action, which alleges that certain Wayfarer parties, through their attorney Freedman, purportedly defamed her via post-litigation statements to the media. Upon questioning by Freedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves, and then of course that's the redacted quote from the deposition, which we can't see, but this is going to clue you in on what they're talking about here in the next sentence. It says, counterclaims filed without retaliatory motive, reasonable basis in fact and law, such as the claims filed by the Wayfarer parties against Lively, do not constitute an adverse employment action within the meaning of anti-discrimination statutes. So apparently what she was alluding to as the only ongoing smear campaign she's aware of had something to do with Wayfarer's counterclaims. And the mistake a lot of people make when they're not following this case closely on both sides is that they assume that Wayfarer's claims were thrown out because they were false or wrong somehow, or they didn't have any merit, and that's not what happened. Moreover, statements by the Wayfarer parties to the media, directly or through their counsel, defending themselves against Lively's bogus claims of harassment, do not qualify as retaliatory conduct. As for the 14th cause of action for defamation, New York law provides an absolute privilege for communications made by individuals participating in a public function, such as executive, legislative, judicial, or quasi-judicial proceedings. Down here, they're citing a case that says the privilege applies to all statements made in or out of court, and regardless of the motive for which they were made. In short, Lively is aggressively pursuing discovery for a defamation claim that will surely be dismissed upon a dispositive motion. In any event, Lively does not adequately address the court's inquiry concerning the undue burden imposed upon Liner Freedman by the subpoena. According to Lively, the subpoena is not unduly burdensome because on December 23, 2024, days after Lively caused her allegations in her California civil rights complaint to be widely disseminated by the New York Times, her counsel demanded that Liner Freedman cease and desist from, in essence, publicly responding thereto on behalf of the Wayfarer parties. Therefore, according to Lively, Liner Freedman has known for more than 6 months that she may seek discovery from the law firm. However, at the hearing on the motion, the court astutely asked Lively's counsel why discovery was needed from Liner Freedman via the subpoena in connection with the defamation claim if Lively knows which statements are at issue. Lively had no viable response at the hearing and does not offer one now. Indeed, the second amended complaint not only identifies the specific statements by Freedman that Lively contends were defamatory, but also conveniently provides link to the publications. In brief, Lively knows to whom the statements at issue were made, where they were published, and when, which renders the subpoena unnecessary and unduly burdensome. The motion should be granted, the motion to quash by Bryan Freedman. So it certainly seems that Lively's smear campaign narrative is crumbling as we see her trying to subpoena the law firm and 107 content creators or social media users. This seems to be going not well for Blake Lively. And I'm not surprised, because she tried to subpoena my information thinking I had some sort of involvement with this, and that's when I knew it was all bullshit, because I didn't do it. So as things progress now, I feel like we're going to see this whole smear campaign narrative get dismissed. There's nothing to find, and at this point it's just a matter of accepting it. But I'm sure she'll drag it out as long as she can, and involve as many people as she can. And the mainstream media and people who don't really follow this stuff closely, they may not understand how destructive that is to a lot of people who have nothing to do with her lawsuit. So that's kind of sad. But I guess we'll just have to wait and see how it plays out in the coming months, and if they actually make it to trial in March. All right, that's all I got for now, but thanks for listening, guys, and I will see you all soon.